So discovery is a formal process of asking the other side questions and asking for specific documents. There's like regular questions that we would ask for production, asking for their witness list, asking for their financial information in a formal process and in a formal way that the other side is required to answer those requests within a certain time period. And so and you can ask if it's a highly contested divorce, there's interrogatories and admissions, and interrogatories are questions that you would ask the other side, and admissions are questions that you're asking them to admit or deny to. Discovery is a very useful tool in that, especially if it's highly contested and you do know that this case is going to end up in front of the judge, and we are going to need this information to use it in evidence or
for mediation.
And for mediation. For mediation, it's a very good tool for mediation because once they know what's out there and what you have, parties are more likely to agree and reach agreements at mediation rather than trying to take this in front of a judge and let the judge make a decision about their entire life after they've only heard their information for a few hours. So it is a very good tool for negotiations and for mediations as well.
And discovery, a lot of attorneys think discovery is used only to locate stuff. Discovery is a great tool to limit evidence as well. Because if you request discovery, and whether it's through production inspection, which is asking for documents, or interrogatories, which is asking for sworn to statements, or admissions, which is saying, as Heather said, admit or deny, if there's information that's not provided to you in the formal discovery request, the other side can't use it. It doesn't matter what they want to do. It doesn't matter if they show up at the last minute with all this information they want to use. If they did not disclose it, they can't use it. And
that includes calling a witness that they did not disclose.
That's correct. And the reason why is courts want all the information out there and known by the parties so that they can have the most efficient trial as possible. They don't want things sprung on the other party in the middle of court, because then that disrupts the entirety of the court. And really, judges really would love for all parties to go reach agreements. That's why they have mediation now, and I would too. And the reason why I say that, even though we're taking money out of our own pocket, you would rather have a decision made by the two parties than a judge in most cases. Two people are probably going to make good decisions for their children, and they're probably going to make just and right decisions on how they're going to divide assets. Now, you have the outliers that occur all the time, right? That they just can't get an agreement done, and that's understandable. Maybe there's no way to have a meeting of the minds, or maybe one side or the other is not providing the information that's needed. Yes, you're going to have to go to court, but attempting to get agreements through mediation by utilizing discovery tools and other things of that nature is really the route to go. And that's the mindset that a client should be in to try to get their case finished. And if not, then we go to trial down the road.